Hi everybody, welcome to another segment of Chuck TV. Let's talk about economic nexus in the state of Hawaii. And Hawaii is interesting. Hawaii's sales tax is actually called a general excise tax. And there's a whole bunch of legal reasons why it's different, and I won't bore you with those reasons in this segment, so please stay tuned. But under their rules, Hawaii has actually always felt that they have the right to impose their tax on remote sellers. So a while back, they enacted a bill, and that bill does officially apply to remote commerce. They always said they had the right to do it, but they nonetheless enacted a bill that made it crystal clear. And what they're saying now is that since the South Dakota versus Wayfair decision was signed, there's no longer a legal impediment to them imposing sales tax, collection and remittance requirements on remote sellers. And that's exactly what they're doing. What's the most interesting thing about Hawaii is that Hawaii is looking to impose these requirements at least a little bit retroactively. And if you remember, we talked a lot in the previous webinar, and certainly the Supreme Court talked a lot about the fact that the South Dakota standard was fairly reasonable because it didn't look to apply a back liability on taxpayers, meaning that it would only be effective from the date the statute was effective going forward. No historical liability concerns. But Hawaii is nonetheless saying that they're going to look to apply this rule historically all the way back to January 2018. Now, I guess it could be worse. You could be saying January 2017 or 2016, but what they're saying is that they will look to apply liability as of 2018, which means that if you met their standard, their economic nexus standard, in the previous year, you will have to pay sales tax for any taxable sales you made to Hawaii, and by sales tax, I mean general excise tax, for any of those historical transactions, even though you might have not collected tax from your customer. That's not specifically an impediment in Hawaii. You can still pay it even though you didn't collect it. But what they're also saying is that if you haven't done it yet, you're still allowed to make what's called a catch-up payment. And the idea is that you make that catch-up payment soon, meaning if you register today, you make your first filing in August, technically you can make that catch-up payment probably in August without incurring any penalty for not remitting that tax earlier. So I think what Hawaii is betting on is that since their retroactivity isn't so severe, and since they're being particularly quote-unquote generous about assessment of penalty and interest for any of those historical taxes that are due, that nonetheless the Hawaii standard will pass the same constitutional muster that the South Dakota legislation passed.